Hello, my name is Thorne Barasa, the president of the ICJ in gluns, and this is our class on jurisdiction. In this class, we shall look into the consent, principle of consent, types of jurisdiction, methods of giving jurisdiction, objections to jurisdiction, and limits of jurisdiction. You've probably heard me say jurisdiction like 7 times now. So, what is jurisdiction, you may ask? And jurisdiction is basically the court's right or the court's ability to hear a case. So the question you ask the court before, or rather the question the court will ask itself before listening to any case is, can I hear this case? Do I have the right to hear this case? Do I have the powers to hear this case? If the answer is no, then the case cannot proceed regardless of the claim itself. Meaning, as you will be told by any person before the court, jurisdiction is everything. And as I've said, jurisdiction is the right or the power the court has to hear a case. And as I've said, more simply put, if for purposes of definition, jurisdiction is the legal authority of a court to hear and to decide a case. And the ICJ's jurisdiction determines whether the court itself has the power to adjudicate a dispute brought before it. So more importantly, so it's a preliminary issue, and it's essential to be addressed before any substantive arguments. What do we mean by preliminary issues? You need to show the court, or the court needs to satisfy itself that it has jurisdiction to listen to a matter. Think about it as something happening in school, right? But then, because you would love for mom to hear about it, you run back home and you tell mom and you ask mom to do something about it. But mom will ask herself, can I do anything about it? If someone has stolen my book, there's only so much mom can do, but it's the school that has the authority to look into it and say, okay, this book was in this person's desk. This person cannot find the book at this point. There was only 3 other people left in class at this time. This is when the book got lost, so we can look for it. So the school, or the class teacher in this case, would have the legal authority to listen and to decide on this matter. And that is why, before even looking into the fact that can we find it, you ask yourself, can I decide on this? Therefore, we have domestic courts and we have international courts. Now, domestic courts derive authorities from the state. By virtue of the court being within a state, for example, the High Court of Kenya, it has jurisdiction by virtue of it being a court in Kenya. Therefore, it can compel individuals to appear, and the citizens are subject to the court by default, automatically. But the ICJ is an international court. The I is in ICJ is International Court of Justice. So it operates in a decentralized system. What does this mean? It means that the ICJ cannot compel states. Therefore, enforcement depends on state willingness, or the principle of good faith, or the principle of consent. In this instance, what this means is international law cannot, we don't have, say for example, in any state they have the police to enforce law and order, but international law does not have police, so to speak, to enforce this law and order. But the reason as to why states came together to make treaties, to make policies, and to make laws is so that they can coexist peacefully. So it is presumed that if you and I have come together to decide that these are the rules that will govern how we live, we are doing it coming from a point of good faith. And it is this same principle that governs states. So the ICJ cannot compel states. It can give judgments. It can pass advisory opinions for agencies. But at the very least, it depends on the state's willingness and good faith to be able to do this. And for us to talk about that, then we need to talk about state consent, because the ICJ does not just assume jurisdiction, because states have their own laws and states have something called sovereignty. Sovereignty means it is the states themselves that make the decision as to how they are supposed to be run and how they function. But the most important part of, or rather the most important concept of ICJ jurisdiction is a state can only be brought before the court if it has consented. Meaning, even if I am the one who has wronged you, I need to say yes for you to take me to court. Seems weird, right? But the principle of consent is grounded in the sovereign equality of all the states under international law. What does this mean? Since all the states are legally equal, no state is more, at least under the law, no state is above the law, no state is bigger than another state. And since all states are legally equal, no state can be forced to submit before the authority of the court. Because remember, states have to buy into the idea that another court will look into what I have done. So, without any prior agreement or without consent given, a state cannot appear before the ICJ. This means that even if state A is to bring a case against state B, the court must first determine whether both states have accepted its jurisdiction. State A says, yes, I accept that the ICJ has the power to listen to this matter, and that's why I brought the case here. State B says, yes, I equally consent to be brought before this court because I believe I did not do anything wrong, and as such, ICJ can take this matter up. So, without mutual consent, the case cannot proceed, even if State A has a compelling legal argument. And as I've said, jurisdiction is a preliminary issue, and this is why it is important for it to be settled first before even the legal argument can be had. So, types of jurisdiction. We've talked about consent, we've talked about what jurisdiction is. So what are the types of jurisdiction? And we have two types. We have contentious jurisdiction and we have advisory jurisdiction. What is contentious jurisdiction? Contentious jurisdiction is the power of the court to hear disputes between states. Both parties must have consented, and it produces a legally binding judgment. And so this jurisdiction can be personal jurisdiction, can be temporal jurisdiction, can be subject matter jurisdiction. What are these, to be specific? Temporal jurisdiction refers to the time the court has to hear a matter. Therefore, there are certain time limits to certain matters, but in this instance, provided that, according to the ICJ statute, a violation has been brought before the court within the time when it is allowed to be brought before the court, then the court can listen to a matter. You cannot come to court and tell us this happened 1,000 years ago and would like for you to listen to it today. That is temporal jurisdiction. Subject matter jurisdiction deals with the question itself before the court. Is this a legal question? Is this something the court needs to look into? So the subject matter itself, what you've brought before the court. And we shall look into these types of contentious jurisdiction in depth. However, contentious jurisdiction is what then gives the court the power to look into the matter. And there is advisory jurisdiction as well. When we talked about the functions of the ICJ, we said that the ICJ does advisory opinions. And in this instance, it also has advisory jurisdiction to provide legal opinions at the request of authorized UN bodies and agencies. As we said, these opinions are not binding, but they carry significant weight, especially for these UN agencies and UN bodies as they make their decision. But as we've said, State A has to give consent to be brought to court by State B. So what are the methods of giving this consent? 3 methods: special agreement, optional clause, and treaty clauses. And we'll look at them in turn. Now, special agreement this is also called a compromise. This is where both states jointly submit a specific dispute, and it is the clearest and the most straightforward. So this state comes, says this is what has happened. This other state comes and says this is what has happened. And so the court has to sit and look into the matter. That is not only mutual consent, but also a special agreement where you have come and you've said, this is what you did. I like the court to hear me. And then this other state comes and says, no, but this is also what you did, and I'd like the court to hear me. And so you enter into an agreement to bring the case before the court. That is a special agreement or a compromise. On the other side, there is the optional clause. Optional clauses are in the form of declarations. Therefore, unilateral declarations under Article 36(2) of the ICJ statute, states give declarations accepting compulsory jurisdiction. So there's been an issue, state A has wronged state B, and as per the auspices of Article 36(2) of the ICJ statute, both of them come and say that we accept the court's jurisdiction on this matter and would like this matter to be had like this and like that. That is what an optional clause or a declaration looks like. But there are treaty clauses too. Now, treaty clauses are also called compromissory jurisdiction, or rather the compromissory method, where there are provisions in international treaties allowing disputes to be referred to the ICJ, and it applies to treaties where both parties are, or rather it applies if both states are parties to the treaty. What does this mean? So say, for example, you have a treaty where there is the Convention Against the Use of Nuclear Weapons, and we say that in the situation where one state uses a nuclear weapon on another state, we will have this taken up with the ICJ. So a treaty is a legal agreement between two countries binding them to the specific agreement or the specific resolutions they have passed within the treaty. So it is more or less contracts between countries on the international scale to do certain things or to act in a certain way. So in certain treaties, it can be made very clear that should there be a violation of this treaty, this matter will be referred to the ICJ. So instead of making a declaration, instead of entering a specific agreement, you just apply from the same treaty itself and appear before the court. And of course, as I said, there was the issue of consent. And so a country can object to being taken to the ICJ. And this can be done in the form of preliminary objections. So what are preliminary objections? Now, before a case proceeds to the merits, a state may challenge the court's jurisdiction by raising preliminary objections. These are the legal arguments to assert that the court does not have jurisdiction and therefore the case is inadmissible. Normally done by the responding state. As we will look into the parties to a case, we will have the applicant state and the respondent state. The applicant state is the state that is bringing the case before the court and saying that this person did this to me. And so the applicant state has to show the court that it has jurisdiction. But the responding state can offer a preliminary objection and come and say that no, the court actually does not have jurisdiction. And once we look into oral submissions, we will then look into how a respondent state argues out their case, and you will realize that normally preliminary objections are given by the respondent state. And they're significant because they can literally dispose of a case even before the court gets to hear it. And as I continually remind us that jurisdiction is a preliminary issue, meaning the court has to answer that question first before it can proceed to any other question. And in the MUN, there are as I said, often used by the respondent, as you will see in a case which I would like us to read, the Anglo-Iran Oil Company case, where the court declined jurisdiction after examining the scope of Iran's consent. And as I've said, where a country has not given consent, they cannot appear before the ICJ. But jurisdiction has its limits too. The court is not all powerful, so it also has its limits. And the limits of jurisdiction are: 1, it is confined to legal disputes. The question cannot be political. The question the court needs to answer has to be legal, not political. Political issues are issues that arise from status quo, what people expect should be, how people feel about a certain matter. But there is how a state can feel about a certain matter, and there's what the law says. Therefore, the court will only listen to legal issues and not political issues. Secondly, it might be limited by reservations made by states, and a reservation in this case is a provision by a state to say that this treaty shall apply to me, this treaty shall not apply to me. And the scope of that relevant treaty, or the specific terms in the special agreement as well, can limit the court's jurisdiction. It can say, for instance, the court can only listen if certain things have happened, not just any violation of this treaty, but say if certain things within this treaty are violated, then the court can have jurisdiction. So these are the specific terms of a treaty. And the third limitation is the court must carefully interpret the jurisdiction before listening to a case, because, as I've said, jurisdiction is everything. If it so happens that the court did not have jurisdiction and it listens to a matter and passes a judgment and it goes on appeal, the whole appeal, or rather the whole case, can be overturned by the fact that the court did not have jurisdiction. Therefore, it is very important that the court satisfies itself that it has jurisdiction. Therefore, summarily, jurisdiction is the legal authority of a court to listen to a matter. And within the ICJ, there is the principle of consent, meaning states must consent to be brought before the court. And there are two types of jurisdiction, that is, contentious and advisory. And more importantly so, jurisdiction is a preliminary matter, meaning the court must listen and satisfy itself that it has jurisdiction before listening to the legal issue itself. And with that, we have now learnt about the jurisdiction of the court, and we shall look into sources of law in our next class. See you then.